Good evening. My name is John Frank, and I'm Vice President for European Government Affairs at Microsoft, and it's my pleasure to welcome you to the Microsoft Center for what promises to be a very interesting discussion tonight. This is the third in our series of EU presidency debates, which we organize with Euractiv and the presidency, currently the Bulgarians. And so we've chosen together three topics of interest to the Bulgarian presidency to try to bring together a discussion that can advance the issues. And I think, we've got an e-privacy proposal that's been widely debated, and yet this provision that we're going to talk about tonight has not gotten nearly as much attention as one might expect. And so I think tonight's debate adds a special contribution to the consideration of how we think about the e-privacy proposal. I'd like to thank you all for joining us tonight. Brian McGuire from Euractiv is going to be leading the discussion, and I will turn it over to Brian to make the formal introductions.
Thank you, John. Good evening and welcome to all of you. Really appreciate the time that you've taken to be here with us this evening. I know everybody's calendar is pretty much jammed this month. Before we begin, let me do some housekeeping with you as well. So please put your phones on silent as well. This is being recorded also. This evening, the format is pretty familiar to most of you, I guess, by this stage. We will do a quick introduction with the panel, 60 seconds, with one exception. Bob Stanky is going to give us a short overview of the topic. Then after that, we'll go into a conversation on this issue. Now, we have a breadth of interest and experience here as well, the technical and the political. So we want to tease some of that out. They will be encouraged to dispute with each other rather than me just lead the conversation. Then after some time, we're going to open the floor to Q&A for you to participate directly with that. Also, the hashtags this evening are hashtag EA debates, and also we have an additional one for this evening which ties in with another event with the Commission, hashtag EPR also. Afterwards, we have a networking reception for you to join us and to spend some time together just after the event as well. So let me just introduce in some sort of protocol order Bogdan Moachkov. He was attaché in criminal matters with permanent representation of Bulgaria to the European Union. We have Daniel Dalton, MEP from the United Kingdom. We have Nicholas Forgo. He is Professor of IT and IP Law at the University of Vienna, Head of the Department of Innovation and Digitalization Law. Welcome to you, sir. Nuala O'Connor, President and CEO, Centre for Democracy and Technology, and from exactly the same city where I come from. Welcome to you, especially. And
you have to tell them what city you're talking about, right?
Belfast. I don't want to out you on that. That's fine. So, from Belfast. She's hidden her accent even more than I have. We have at the end here also, who's going to speak in just a moment, is Robert Stanky. He's partner in telecommunications, media and technology law at Davis Wright Tremaine. And let's start, Nuala, with you. Quick introduction, your interest in this subject and what you do.
CDT is a digital human rights and civil liberties organization focused entirely on the rights of the individual in the online world. Our three main focuses have been historically privacy and data, so consumer and commercial use of data, freedom, security, and technology. That team deals with anti-surveillance, limiting the intrusion of the government into your daily lives, and freedom of expression. I think actually that team gets the least attention, and it's probably one of the most fractious conversations we're having right now globally. But our interest in this issue, obviously, is the potential for intrusion by governments on a permanent basis into the apps and the devices that really power your daily lives, your vie quotidienne, and how important it is for us to set boundaries and enforce existing and perhaps new law in this area.
That was neatly summed up. Thank you. Bogdan.
First of all, thank you for the opportunity to participate in this debate. Thank you too that you actually very successfully pronounced my family name, which is a hard thing to do. Yes, as you said, I'm working for 4 years in the Bulgarian Ministry of Justice, and since I'm here in Brussels, I'm working on several criminal files, including e-evidence and data retention.
Thank you. Dan.
Well, Dan Dalton, I'm a British MEP from the West Midlands. I sort of come to this from a consumer point of view, actually. I started off in the Internal Market Committee, dealing with a lot of the digital files. from that perspective and looking from a consumer perspective, and ended up in the Libe Committee of the European Parliament, which is, of course, the one that focuses on things like GDPR, e-privacy, and now e-evidence. So I've ended up taking on a portfolio of quite a lot of the digital files that are coming through. But I do look at this from the start, from a consumer point of view, and the fact that the digital revolution has actually fantastically sort of democratized being a consumer. And I think that's quite often not mentioned, particularly in the e-privacy debate.
Thank you. Nicholas.
Thank you, Brian. Good afternoon. My name is Nicholas Forgo. I'm an academic. I'm an Austrian academic with 20 years of academic history in Germany, which per se brings me into data protection and data security, which is my main area of expertise and interest. I've been quite intensely involved in the academic debates on this issue for the last years, and I'm very, very happy to be here and to debate this in Brussels too.
Thank you. Bob, before you kick off, who you are and where you're from.
So I'm Bob Stanke. I'm a lawyer with the law firm of Davis Wright Tremaine. I've been working on these kinds of issues for many years, starting with some of the early data protection issues, but also the Data Retention Directive, and now on the Electronic Communications Code and the e-privacy regulation. I guess my extra perspective for this panel is working with technology companies and telecom companies and trying to understand what these regulations, how they apply to them and what they mean for them, and actually what kind of compliance may be required in order to meet the obligations that they have.
Thank you. You have 5 minutes, sir. Off you go.
So we thought it may be useful before we have a lively policy debate around some of these issues, because there's certainly a lot to talk about, to maybe spend a minute or two talking about specifically the e-privacy regulation, to let you all have a baseline of knowledge about exactly what's at stake here and what's being discussed in the legislation. So Brian has graciously allowed me 5 minutes to sort of give you this perspective to maybe frame our discussion. So starting out, as John mentioned, we have the e-privacy regulation, which is very much focused on communications confidentiality. So its main objective is to ensure that there's no interference with communications during transmission over communications services or communications networks. As with the existing law, which is the e-privacy directive, the confidentiality is assured for both content and metadata related to communication. So that would be the traffic data, location data, and also subscriber user data as well. What's interesting about the e-privacy regulation is it's part of a trend to expand and allow for the same regulation that applies to traditional telecom providers to extend to new forms of communication services. And we're seeing this in other pieces of legislation, obviously, that are being discussed in Brussels, including the Electronic Communications Code. And so what that means is the e-privacy regulation has a broader scope than existing law. It moves beyond strictly what is referred to here as network-based communications, which are the familiar telephones and internet access sorts of services that you have, and moves into these non-network-based services, commonly called OTTs. So it's things like messaging and voice chat apps, email. And what's interesting about the e-privacy regulation proposal is it goes further than some of the other proposals and legislation that's working its way through Brussels. It also includes any app that has a communications feature associated with it. So these are referred to as ancillary features to the app. An issue that's floated up in the discussion of the e-privacy regulation so far, which I know we're going to get to on the panel, is encryption. So there has been a proposal made by the Parliament to require communication service providers to implement technical measures to protect communications, and pointed out in that has been a reference to end-to-end encryption. And let's leave that and come back to it later. So where does legal intercept and other sorts of government access to data laws come into this? And that comes into an exception to that broad principle that I just mentioned about ensuring communications confidentiality. And so this is the public interest exemption, which is found in Article 11 of the e-privacy regulation. And on the screen here is actually what Article 11.1 says. And just looking at it at the high level, it's essentially that any member state or the union itself can pass legislation that infringes on this confidentiality principle, this broad confidentiality principle, if that law meets fundamental rights and freedoms, which means it must be consistent with the Charter of Fundamental Rights and European Court of Justice opinions, and is also necessary, appropriate, and a proportional measure that fits with one of several public interest justifications that are set out. And the public interest justifications that we have are the following: national security, defense, public security, investigation of criminal offenses, and then a broad sort of last category, which is other important objectives of general public interest. And you'll see here references to taxation, public health, and social security. So this is what the Commission originally proposed with the e-privacy regulation, is to allow for member states to provide for laws that would be based on these principles and allow for legal intercept or communications data retention.
You got 1 minute.
Thank you. And we also just wanted to give you the context for the e-privacy regulation. There are other pieces of legislation that are currently in the digital single market set of proposals that are relevant to this topic. One is the Electronic Communications Code, which I've already mentioned. So in the code, which is essentially the body of law that regulates telecom companies, that will now be expanded to some OTTs. That allows for legal intercept authority over the communication services within scope for the code. But it's also relevant to look at the e-evidence regulation, which is also proposing to allow for laws for and requiring laws for government access to stored data. This wouldn't be intercept live real-time data, but it would be stored with a communications provider. And that also is a source for law in this area. E-privacy regulation sits in the middle because it is it really is the one framework piece of legislation that we have, that Article 11, that provides for communications data retention obligations and legal intercept within the European system, which is a bit unusual that there's not another framework out there. And so with that, why don't we move to the policy discussion?
Thank you. Can you put the slide back up? Is that possible? Let's keep it up a bit.
Yep.
No, the one with
the last one?
Yeah.
I can try.
Yeah, if you can. Nicholas, when we're talking about the EPR here, how does this differ from other regulations, and where do you see the synergies between them?
Well, actually, I don't know whether this is, this is probably part of the problem, that it does not differ that much in many ways, right? It's very, it's very detailed in many ways, and it's very similar in some ways with the General Data Protection Regulation, and that is already one of the problems, that the relationship between GDPR on the one hand and the privacy regulation on the other hand is a constant, painful process to be discussed. On the other hand, it's different from the existing e-privacy directive from 2002 in one very important point, which is that it should also be applicable to over-the-top services. And that, of course, increases the importance of this piece of legislation significantly. Whereas at the moment, this is mainly something which is very specific for telcos. It will certainly affect more or less every startup in Europe.
Practically, what does that mean?
That means that everybody who is thinking about doing something on the internet in any role will not only be regulated by GDPR, but also by this piece of legislation.
Dan, how does that affect the market?
Well, if you look at the Parliament proposal, it could affect the market quite substantially, because the grounds of consent are much more limited than they are under GDPR. Effectively, consent is the only grounds to process data. So I think there's a significant challenge. We're already seeing a massive challenge with GDPR implementation in terms of how companies and individuals and organisations are trying to deal with it. E-privacy goes a lot further than that. I've described it as GDPR on steroids.
Bogdan, you worked on the digital evidence side as well. Where do you see the alignment between these pieces of legislation?
Which one?
The e-evidence.
The e-evidence. Actually, I would like to first say that that what the e-privacy regulation, with, especially Article 11, would like to do is just to strike this balance, to find a solution to open the door for for protecting not only the privacy but also the public interest. And actually the alignment which should be done is to align the evidence regulation with the e-privacy, and of course with all of the requirements which were included in the court judgments. All the court judgments which were issued in last years on this topic.
Okay, Nuala, it may be because of our particular upbringing, but there's a certain cynicism today about we prepare legislation essentially with the objective of functioning within a benign democracy which works in the interests of all people. You may have read the newspapers recently about certain governments across Europe that are moving in a position which is not necessarily that healthy. Are you confident to have a right-wing interior minister looking through your data?
The democracy is in peril. Let me be as non-nuanced as I possibly can.
No,
and I share entirely the view. And let me first start by saying, out of respect for the fact that of my current accent, I'm not one of these Americans who has been grousing about GDPR. I described the passage of good, vibrant privacy law as Christmas for those of us who've been working in data protection for as long as I have. We have real concerns about the e-privacy regulation. On the other hand, though, just looking at the definition of public interest. First of all, I hate the word balance. In this context, balance, privacy versus security, having worked at the US Department of Homeland Security, in times of national crisis, privacy loses if it's an either or. These have to be values that are sympathetic to each other, that are sometimes in conflict, hopefully both addressed and thought of by legislators. This is almost an Orwellian name for this regulation. I don't see this as a privacy regulation. I see this as an open door for government surveillance.
But your security is important.
National security, obviously, the safety and security of individuals, of citizens. I'm going to whip out, I'm the mom card. You know, I care about my children's safety. But I also care about their liberty, their freedom of expression, their ability to conduct their daily lives. And an all-seeing, all-knowing government is not the world in which I want to raise children.
Dan, do you have the same concern?
Yeah, I mean, I think it's a balance, isn't it? I mean, I personally would always prefer to give my data to companies than I would to governments, because ultimately companies want something from me and I can give companies something, whereas governments have a monopoly of the role of force over me completely. So I share some of the concerns said, but I think also there's got to be a balance, because, for example, when you have the worst situations, you have terrorist attacks, for example, and then you have reports, for example, that some platforms are not giving the data. I think most people would say in those circumstances they should be able to give their data and they should be obliged to give that information. But it's a balance. And I don't think we should be having this general ability for governments to monitor. And it's not just right-wing governments, it's left-wing governments that are just as bad. All governments tend to have, once you give them a little bit of this power, they tend to go too far. And you see that with even those governments that are not.
So can we open the door at all, or should we encourage lawmakers to push back and to close the door and to find a different solution? And to keep this in context, for example, there are more 2-year-olds using their mother's guns in America that kill people than Islamic terrorists.
Yes, quite, but you've got to get a balance. I think you can't have a situation where you can thwart terrorist attacks, or you can find out actually information from terrorist attacks, and that information is available but not given to governments. I think most reasonable people would recognise that you need to do that. And the only way you can deal this in a broad piece of legislation is getting a balance.
Okay. Bob, if you want to deal with process and you want to open the door on this, how do you regulate that information once the door is open? Do you need specialist judges to oversee the warrants that are necessary? Do we need warrants to interrogate the data? Do we go for a no-knock policy where, how do you navigate your way through the house once the door is open?
So, I mean, that's one of the critical issues here, is we have an opportunity with the privacy regulation and Article 11 to sort of set a framework for how these kinds of rules would be applied at the member state level, and setting a standard that we can all agree on that facilitates cross-border trust with the evidence regulation or other sorts of facilities. And so certainly I think there needs to be a consideration of getting warrants for certain kinds of intrusion, especially legal intercept, certainly even if it's targeted, but also if we're talking about bulk intercept, which we found out about in Snowden. There needs to be some sort of judicial oversight, and I'm not saying that necessarily has to be micromanaged within Article 11, but it's something that should be discussed within the consideration of how the e-privacy regulation should be drafted, and trying to provide the tools for member states to get that balance right without having to be challenged in court and having to litigate it over and over again.
If you have a gatekeeper in control of the warrant process and in control of the discovery element of this, should they be specialists, or would you trust a general magistrate to issue a warrant in this kind of instance? How specific should the expertise be when it comes to dealing with this subject?
I think the experience, particularly on some of the more sensitive legal intercept cases, is it requires a special kind of judge. And I think we've seen this with the IP Act in the UK. It's someone who has to have the ability to, they know the issues, they also have the security clearances, and they're familiar with the mechanics of how they should be judged, because these aren't sort of average things that a magistrate would be dealing with. So I think certainly that would be an important part.
But Nicholas, we're getting to the point where they are almost going to become average processes. So the tax collection authority, the Inland Revenue, they are going to have access to your data if they can prove it's in the public interest to do so. How do you process? How do you control the data flow then?
Yeah. Actually, I think this is one of the most important issues here, and this is one of the reasons why I don't like the word balance in this debate too much, because there is a fundamental issue at stake here, which is security of communication on the internet. And that one of the lessons we learned from the Snowden revelations was we need end-to-end encryption. And end-to-end encryption is one of the answers given to all these scandals. End-to-end encryption, in my layman's technical understanding, means that communication cannot be intercepted if it works, right? So I have never met anybody who could help me in understanding how this piece of law then should work if on the one hand we have the possibility that law enforcement or whoever, tax authorities, should be able to wiretap the communication, and on the other hand we have end-to-end encryption. You can't have both at the same time. And then my answer would be, this is no question of balance, it's a fundamental security issue of the whole internet architecture.
Bogdan, in council, how does this argument play out?
I wouldn't actually say that the balance is a empty word. Actually, we are talking about necessity here in the criminal law sense of this term, and we are here in the middle of a cyberspace discussion. But actually, I would like to take you out for a moment from this. And do we have the right to break in somebody else's home? No, we haven't this right. But if, for example, we are going nearby our neighbor's house and we see that there is fluid in it, and do we have now the right to break her or his windows and break in and save his or her property? Yes, we have, and this is the balance which we need actually also in the cyberspace.
But do you really think that it's as linear as that you can identify the risk in such a clear and precise way?
Yes, I think, and that's why we have all the guarantees, which are included also in the e-evidence regulation, the court order, etc.
And this issue that Nicholas touched on as well, that the end-to-end encryption, Parliament supported end-to-end encryption, I believe, and yet, how do you reconcile these elements? Is it possible to do that?
I think that's the challenge, isn't it? That's the most difficult challenge when you've got end-to-end encryption and you've got complete confidentiality of communications that are guaranteed by that, yet at the same time you need government access to it for whatever reason. You've got a challenge, and that's where I understand that we don't like the word balance, but there's always going to have to be a level at which we as policymakers and as all of us say, yeah, that's an area where someone's right to privacy can be a little bit lower than the public need to go in and have a look at it. But where you develop that has got to be so small, because I worry about Bogdan's example a little bit about the house, because once you give government the ability to look at everything in that area, all experiences of governments that we've ever seen is that they go further than that. I mean, you look at how governments have abused terrorist legislation in many ways. I can give you lots of examples of that. So we've got to be very careful and very narrow about how we define it.
No, you I presumably agree with that, but how do you find a solution to that? If there's going to be legislation, if public perception is that we're not doing enough to make security a reality in the digital age, how do you appease all parties in this?
We want our governments, I think, all around the world to be effective and hopefully limited in the intrusion. I agree with the statements that the provisions around end-to-end encryption are just profoundly incompatible with the rest of what the apparent intent of the directive is. We've had this debate, as you know, in the States on end-to-end encryption for 2 decades, and to a certain extent we feel like it has been asked and answered. End-to-end encryption is ones and zeros, it's math. It's either broken or it's not. And when you stack up individual rights of privacy, which I understand sound theoretical to some corporate leaders or individuals or members of the legislature, against national security and preventing terrorism, I understand why that balance does not feel right or correctly decided. But it's not the right construct to look at the analysis on encryption. It's a security versus security debate. It's not only individual security of my phone or my device, it's national security in that nuclear power plants and transportation grids and energy grids and sensitive government operations run on encrypted technology. So it is a national security versus national security conversation. So I think the construct of the debate often is incorrectly framed. I prefer, and again, based on my experience in government, in the private sector, and now in the civil society world, the construct that stronger security around the systems of the internet, including our own devices and the devices in our homes and our cars and our schools and our daily lives, are protected to the highest level of security. I think law enforcement and national security forces have a wealth of information. Some people call it the golden age of information right now, with all of the data that the Internet of Things devices in your homes and on your bodies and everywhere else are spewing. I don't think breaking encryption is the solution.
Okay. Well, we had a book launch here 2 weeks ago. It was called The Quantum Spy, and it detailed with some accuracy, we're told by the CIA, the US efforts to beat China in terms of controlling the internet through quantum technology. This is an old conversation. Once that end game plays out, either China will dominate or United States will dominate, and Europe will be left somewhere in the middle trying to catch up. What do we do then? How do you manage a legal process where encryption just doesn't exist anymore? How do you manage privacy at that point?
It comes down to requirements that we have around data protection and enforcement, and allowing for companies to step forward and have that kind of trusted architecture in order to make it happen. As we get to more and more technology, it's an arms race, and to some extent, I'm not sure that we necessarily need access to, by law, access to apps. There's plenty of information, as Nuala says, available in the network, and traditional ways of getting access to that are sufficient to provide for high levels of security, I think. Having something that requires a multitude of apps to provide these kinds of tools is something very troubling, because it is so broad. It stifles innovation in the sense of making it harder for smaller companies to get started, and I think that's something that Europe needs to focus on, is the ability for new entrants to come in and build something that touches on this space and not be put off by regulation that's intense here and less so in China and the United States.
Okay, Nicholas, this brings us to the cross-border dimension as well. It's one thing to deal with these issues in one jurisdiction. What happens when we're dealing across Europe and then in a transatlantic basis as well? How does this e-privacy regulation hold up in that kind of dimension?
Well, actually, I think, I mean, again, I would be very cautious here because I think, I mean, one of the basic promises of GDPR when it was launched by the Commission in 2012 was that Europe would establish some kind of gold standard in privacy. 6 years later, I would say, I don't know whether this has come into reality 2 weeks after GDPR has started to be applicable, directly applicable. And I think that we are facing the same risk once again, which means that, the e-privacy regulation might produce a lot of burdens and a lot of costs on European stakeholders and not really affecting global players not based in Europe and therefore not necessarily complying with European law.
Okay, Bogdan, is there a way in which the complexity of cross-border management of data and this regulation, is there a way that you can build in extra layers of security from a commercial perspective because of the obligations of telecommunications providers, because of the apps providers? You know, we're functioning in a single market. Can we have different markets functioning for privacy?
What I wanted to underline here is that actually that the e-evidence regulation and also the directive, actually, it is a whole package of the Commission which was published in April, actually in some way also tries to improve the situation for the service providers, because if they face different approaches across the whole Europe, the whole European Union, that is actually harmful for them, because they need to they need in some way to get all the expectations from all different member states in different ways, which is actually a very big problem for them, also in terms of expenses. For example, for complying all different production orders which came from different countries across member states.
And the regulation has within it a specification that these companies must provide, if not a department, a system of training to provide quick response for the production of data. Is that right?
Right. So there's hardwired into the regulation a requirement to have procedures in place. So it sort of assumes that you're going to be asked to provide this kind of support under law.
How do you see that play out? Do you see this as just a way to make it much easier for us to provide our data for the gate to be opened, or is there a mechanism to push back with the companies? Can the company refuse, and can they go to, where do they go to push back on a production order?
They would have to go back to the law that creates the obligation on them. So there's still a requirement that there be a valid warrant that's delivered to them, and these are just the procedures for intake for that and evaluating that. But what's challenging about it is it means that you know, any company that's within whatever the definition is within national law has to have procedures in place, and rather than just sort of, and for large telcos that may not be an issue because they've been doing this for years, but for smaller companies, for apps, it becomes really complicated, and it's a GDPR-like burden on them.
Okay. Nicola, the European Court of Justice as well has ruled a number of different cases on this and the fundamental freedoms, fundamental rights being applied in this. So imagine we have a small app provider and the production order is produced. They don't think it's compliant. How do they find their way through such an expensive legal system and rebut?
Well, actually, it will take them for years to go through this, and most probably they will not be on the market any longer than after this battle. So I don't think that, I mean, this is not really an option to go for, I would say.
And so the production orders...
The few cases we saw in front of the Court of Justice of the European Union are mainly run by individuals who have a political idea behind them. Schrems, for example, would be one good example. But it's not a minor company somewhere based in a garage having a good business idea and then trying to fight the European legal system in order to make that happen. I don't think that this is realistic.
So say, hypothetically, a company refuses to disclose the data and appeals. What's the penalty going to be then?
Unclear. I mean, it's up to national legislation not existing yet. But I mean, significant for, obviously it needs to be significant, so otherwise it would not be compliant with European rules. But I mean, the exact amount is unclear at the moment.
So either you have a harmonized, Dan, either you have a harmonized playing field in terms of the penalties that are going to be applied, or you have a free-for-all market where you can take your chances according to the penalties that are going to be there for refusal to produce the data, correct?
Well, I guess it depends how the final regulation comes in force and what whether you have a European system of fines or whether it's applicable on the national law, where there will be changes. But I mean, in this example, I don't see why any small business would bother fighting it. They simply wouldn't be able to.
Do you find that just? Do you find that a fair use of the law?
No, I don't. But I think the situation we've got into with GDPR, with e-privacy, and now with the evidence is that these regulations are tailored for the incumbents already in the market. And I think you see with Facebook, when they were in the Parliament in the last couple of weeks, are very keen for new regulation in this whole sort of privacy sphere, because they will be able to comply with it. They have the means to comply with it. Small businesses don't, especially one-man, two-man startups in this field who have developed a huge amount of the growth in the last 20 years. They're the ones who are going to have the most difficulty, and I think that's why it's incumbent on us who are doing the sort of, as policymakers, to make sure that we always keep that in mind.
Okay, Nuala, as Dan mentioned, the European Parliament heard from former Cambridge Analytica employees in the last few days. It's something really in people's minds. What lessons do we draw from that?
I'm so glad you brought up that case, because after Snowden, I think it is the most consequential moment in the technology sector, frankly, in the last decade. I judge this not only in the news, but also in the anecdotes of the people who call me, people who don't work in technology policy, from, you know, old friends from college who say, what is going on? And it has affected real people in their real lives. I think this is almost the Snowden moment for companies. That individual consumers and citizens have awoken to the fact that trivial data, not just sensitive data, not just data that is governed by even the sectoral approach in the United States, but things like what's your favorite color or what kind of dog breed do you have at home, are being used to create not only profiles but make decisions about advertising and, more importantly, content that is affecting people's worldviews online. And so this moment has had real staying power in the US press for sure. We've seen, obviously, the testimony on both sides of the Atlantic at this point. I take with great care, I think, the point that we do not want legislation that is going to solidify a power structure or incumbents in telecom or in tech, but people are upset, concerned, and outraged that they feel like they have less control, less agency, and less authority over their own data and their own decisions.
Drawing off that, Bob, do you think that this is a moment where we begin to view e-privacy data from a different paradigm, that we start to reshape our thinking about what's important in this structure?
I think so. This feeling and this awareness of intrusion, I think, is something that people may not have focused on before. Snowden, it may have been more theoretical in the sense of, what data was being collected by telecom companies and then allowed to be accessed by the NSA. But this feels more personal and more direct. It's things that people know. I loaded that app on my computer, and so I know it's been exposed. I may have gotten an email about it, and so I think at that stage it does become much more of a turning point, and probably a moment for, in the U.S. it'd be really interesting to see if there's legislation that finally comes from this after fighting European data protection legislation for so many years.
Okay, we'll take a couple of questions at the moment, so you can get yourselves ready for that. Dan, do you think this is a turning point as an elected official? How do you see yourself addressing these issues with your constituents?
Well, I think the key difference to this particular scandal is that there's a political element to it as well. The fact that people feel, now I think we don't know enough to know what the evidence are, but people feel that these might have impacted in election results with Brexit and with Trump potentially. And I think that means that there's a much bigger focus on it, and there's a political focus on it, and people that have a view on one side of those two arguments are now feeling that they've been maybe misled or things have changed because of that. And I think that's actually probably, from a political point of view, the biggest difference with this.
And do you see this sensibility shifting people's perception of what public security is, what national security is? Because if you can influence the course of democracy, and if it's done at the behest of an external agent, whichever large country that may come from, Do you think that people see that difference and will push back against the legislation as it is now, and they see security as a different dimension? Or is it too far?
I think that's probably more of an elite, establishment type of view of what's happening. I think
You're the first person to accuse me of that.
Sorry. But I think well, we're all, aren't we, sitting here doing this debate. But I think what most people will feel most about this is they didn't even know that that's the data that people have on them, and that that's the data that's been passed on to other people that they never knew about. And I think this general feeling with privacy, I think a lot of people have, is they just don't know what data's out there about them. This has put that clear in front of them, that this data is out there and it's being used against you potentially.
If you get a letter from your tax authority disclosing something that you know was securely held, do people change their mind at that point that the government's not acting in their interests?
What do you mean? So if,
for example, that the production order is produced by a tax authority, the data they derive from that production order discloses something which is incriminating to you. Do you think people's sensibility changes that because now the government's after you? It's not the company.
But then that opens up a whole other debate about that the government level of control there as well. And I think just on e-privacy on that, you see a big difference in the amount of control there is now on private companies and the data they can hold on you, given quite wide exemptions for public safety that were there, that actually it completely changes the dynamic. The private companies can't have the data on you, but the government can have all the data, and I think that's a big shift that we need to keep an eye on.
Questions? Hands up. Tell us who you are and your question, please. Short questions. Who's first? Wow. Yeah, I think this is technical. Let's see how I do in a moment. The next stage for this, Bogdan, how long is this process going to be played out? And do you foresee a consolidation of the law in the future as well? So, because we spoke a lot about the overlap. There's a lot of similarity between these different pieces. Are we moving towards a more harmonized structure for the legal system?
Yeah, on the first part, on the length of the process, actually I have forgotten my crystal ball with me, but you know that in Council and in Parliament, terms are very vague in terms of it's hard to predict. You know that the ambitions are for, if possible, to go with the proposal fast, but taking into account also that the mandate of the Commission and the Parliament is expiring soon, that would be very hard thing to do. But so it's not, of course, clear on that point.
Dan, do you see in terms of the duration of the process that this could be another TTIP moment where people gradually wake up to what they're told, at least, is happening in the legislative process, and they begin to rally against it? Is that something you see there's a public reaction, a public movement against the e-privacy regulation?
I don't think e-privacy. I think actually what we've seen has probably strengthened people's views that the Parliament have got it right on e-privacy. Now, I personally oppose the Parliament position, but the feeling I get is that many people think, because of what we've seen with Cambridge Analytica, that actually e-privacy might now be on the right lines.
Okay. Nola, what's your biggest fear here? What's the worst that can happen?
It already has, no.
Hasn't.
No, you're right, it hasn't. The all-seeing eye. It's this lack of a presumption and the due process necessary. These constraints already exist in many parts of the world, to have a warrant, to have a subpoena, and a narrowly defined scope of search. This regulation broadens that scope, I think, so greatly that it is hard to predict all of the mischief that one might get up to as a government actor. And as we live our lives online, as all of our most granular data is online, and we conduct ourselves in every aspect of our lives in the digital world, we actually need, I think, to strengthen the boundaries around the data that is held by legitimate and responsible companies, and strengthen that boundary. You're absolutely right that the Snowden revelations showed the blurring of the line between corporate data sets and government data sets. We need to strengthen that boundary.
And how do you do that?
Laws, regulations, but also great work that can be done inside companies to develop privacy by design frameworks, ethics by design frameworks. Good companies, I know Microsoft has supported federal legislation in the United States for many, many years. there are ways to protect through not only policy but also technology and limiting the amount of data that's collected and how it's used and when it's discarded.
Nicholas, how do you see this play out? What's next in the process? And do you see any roadblocks that really bring this to a halt?
Well, I don't know. I mean, I find it rather frustrating, honestly speaking, that the main driver of the whole debate is whether the mandate of the Commission is going to end in the near future or not. This is, I mean,
you don't live in Brussels, do you?
Well, yeah, I don't. I mean, this is the advantage of being an independent academic. It doesn't have any importance what I say, but I can say whatever I want, right? So I find this.
Some people say that of the Commission also.
I mean, no, but seriously, I mean, in my perspective, neither the e-privacy directive nor the General Data Protection Regulation are a success story for the European legislator. Both of them have serious weaknesses that are broadly seen everywhere. And I don't know whether it's a good idea to rush through another piece of legislation now, having very, very strong impact on everybody's life, just because the mandate is going to end. I would really appreciate if it took the time to analyze really carefully what GDPR's impact is. And one of the most obvious impacts I see at the moment is a lot of frustration everywhere in Europe because of all these burdens coming everywhere. And at the same time, a Facebook CEO coming after the Cambridge Analytica scandal to the European Parliament, not answering a single question there, and then after 75 minutes saying, I'm sorry, I need to take a flight, right? So this is the outcome of GDPR at the moment as it's seen by an academic at the moment. I don't know whether this is the success story really needing to lead to the next piece of legislation.
Bob, what do you think of that? Are we dealing with too many things too fast?
I think it's very likely. I think we've just gone through an enormous transition with the GDPR implementation. There's a lot that needs to be worked out there and a lot of lessons that can be learned from how that regulation is being put into practice. The concern here is that the e-privacy regulation has, it has a number of different elements in it, but and it's kind of a grab bag of different slices of digital policy. And a serious evaluation of whether all of those issues are properly dealt with. In some ways, do they need to be dealt with? Is the existing law sufficient and provide enough structure and protections? That sort of thoughtful discussion, I fear, hasn't taken place on the different pieces of it. And as you mentioned in the opening, there hasn't been a lot of focus on this particular issue of Article 11, but it's enormously critical. And so taking the time to deal with those issues rather than negotiators worried about negotiating cookie walls and digital advertising issues, and this gets left to a technical working group, is the ultimate fear, I think.
Okay, you fear technical working groups more than anything. Of the audience, you have a question, sir? Hi, how are you doing? Good to see you back. Just tell us who you are and
Melberes from the legal service of the Commission, but certainly on a private matter. So, to Nuala, I'm asking you something about that very well-known application, the Twitter account of President Trump. I've just read that he modernized his devices, so he's not anymore on a Samsung Galaxy S3 as he was as a candidate. He has got several iPhones, and they undergo security checks on a not daily but on a periodical basis. But the Twitter phone is not. And that has got also the authorization for taking pictures and so on, which is inherent to the Twitter account. What do you think? Is it a real possibility that this account is wiretapped?
Sure.
That's
not the question I thought you were going to ask. I thought you were going to ask, should the president have a Twitter account at all? I have a lot of views, again, speaking as a citizen, as a former administration official myself, and I worked in a Republican administration, so I feel it's especially incumbent to talk about these issues, about the dignity of the office and how to conduct the business of the nation. I've actually talked to the Twitter people about it, and I think they are in a particularly difficult situation. And I think a number of Americans questioned whether or not they should continue to allow the president to tweet given some of the comments and whether or not they met the community guidelines of the company. Ultimately, they decided to leave the account up. And in fact, I've come to the view that that was the right decision because it is an issue of international importance to hear the voice in real time.
You still think that?
I'm not saying it's a pleasant experience. The U.S. courts have just upheld the rights of the citizens not to be blocked from hearing and seeing and following that account. And I think that's an incredibly important moment for freedom of expression, for citizens' rights. I've said a lot lately that we're taking the democracy for a road test, and I think we will pass, but it's going to be a very interesting and bumpy ride.
Any other questions now? Yeah, John.
A question for Bogdan and Dan about the consideration during the legislative consideration process about this Article 11. And just an observation, yesterday the Council of Ministers met, I think in Luxembourg, and they actually televised their discussion. And one of the questions that was put to the ministers was, should the e-evidence proposal be expanded to include surveillance or real-time intercept? And it was sort of like nobody appreciated that it's already sort of included in the privacy thing, and nobody there sort of, there was discussion. Some member states said, yes, we should come up with an additional proposal on it. But I don't remember anybody saying that it's already covered, we don't need to think about it. So how much attention have member states and the Parliament paid to this Article 11?
Yeah, maybe first, I'm not a specialist on e-privacy, so the idea of Article 11 if e-privacy regulation is just to open the door, but with all the alignments with, of course, all the GDPR regulations of Article 23 should be covered, all the requirements, and also, of course, the requirements of the court judgments, which I mentioned earlier. And e-privacy is not regulating the specific procedures for criminal authorities, judicial or enforcement authorities to have access to store data, or so it's just e-privacy's Telecommunications Act is substantially, it has nothing to do but just having the possibility included for actually for derogation of Article 5 about the confidentiality, but nothing more.
And I mean, in the Parliament, to be honest, we had some discussion on Article 11, but it wasn't the main focus or the main stumbling block. I mean, most of the work was on the other areas, the digital advertising type of issues. Article 11 was not a major part of our discussions at all. And I think that maybe answers your question a little bit to what was said before. It was skirted over a little bit.
You want to follow up on that? Okay. Let me see another question.
Just one comment, if I may. I think that is one of the fundamental problems here. I don't think that too many people in the Parliament do have the technical expertise to understand what Article 11 would mean from a technical point of view. I don't talk about the legal implications, which are also rather challenging. But technically speaking, I don't really know whether there's anybody in the Parliament being able to explain to my little garage startup what exactly they would need to do to make end-to-end encryption accessible, end-to-end encrypted data accessible to public authorities.
Okay. Bob, you're dealing here not just with something which is sent and received. The regulation, I think, it speaks about, for example, an email which isn't even sent, is still in the inbox, or something which is described as in transit as well. Now, we're talking essentially about messages and things like that, and people kind of have a handle on that more or less at the moment. But what if we're talking about Alexa, and how private and how secure is this kind of observational machine at home which records should be secure, and then the CAA, NSA, another public authority wants to access that? How secure are we there?
Well, I mean, it's certainly we've already seen, I know in cases in the United States, it is a hot area of interest for local police. There have been a number of cases where someone's died in the hot tub, and they want to find out if there's any ambient noise in the room to find out if there's some story behind it. So I think we would see even more interest in these kinds of technologies as they roll out. This kind of approach that we see in the current draft of the e-privacy regulation would seem to open the door to requests for that kind of data, which I think would open up the whole issue of how secure that would be. You know, would it be possible to deploy encryption to protect those communications if you had to build in a backdoor to comply with a legal intercept request? So I think it's very troubling, and these are the kinds of issues that really should be reflected in a discussion of something like Article 11. If in fact this is the vehicle for having some sort of framework for this balance that we've been discussing, you know, are there certain kinds of technologies and certain kinds of services that are we have certain rules for, and perhaps we have different rules for other kinds of services and technologies that have a higher standard, or that we just don't think it's too intrusive to privacy, those listening devices, that we don't want to enable law enforcement right now unless there's a robust discussion around it.
Say we deal with domestic abuse, or we deal with tax issues,
Right.
which are maybe discussed at home as well, or there's some other probably financial element that's being discussed as well, and the public authority takes a dim view of that too. Say it's been observed for the domestic abuse, which I think most people would say that's a good.
It's a crime. It's a serious crime.
It's a serious crime and a good
Right.
thing, and a good thing to observe, because it's hard to get the evidence otherwise.
Right.
And in the process of that, you come across evidence which is related to some sort of tax difficulty, not even evasion. How do we process that kind of information? How do we filter that kind of information? Do we use normal discovery terms, or do we have a new set of rules that need to be applied to that, where a public authority can only deal with the issue that they were seeking in the first instance, and they have to disregard all the other information? How's that going to work?
It's a great question. I mean, I think the initial thought would be the legal procedures that already exist for challenging evidence when it's brought to trial would apply in this brave new world of pervasive sort of communication surveillance. So it would be looking at the scope of the warrant that authorized the initial wiretap and saying, is this additional evidence that's been acquired through that? Is it somehow flowing from that initial scope of that warrant? And those would be hard issues that judges would have to deal with. It's a new environment. There may need to be an additional level of sophistication and training among judges in evaluating those kinds of decisions. But I think ultimately the same kind of principles would be applicable.
Nicholas, if you take the view of tax issues, for example, does this e-privacy regulation favor the rich or the poor? Because if you're rich, you can afford the lawyer to push back on the production order. If you're poor, middle income, no chance.
Probably, yes.
So it's inherently unequal.
Also, I mean, and again, I think more importantly, it's also more protective for big players than for small on markets, on developing markets. So it's not only a consumer issue, it's also an issue for market developments. And coming back to that question, I would like to add that most probably there will be significant differences in national legislations on this issue, so it will not be harmonized on a European level.
Dan, if you're a public authority, would you go after rich people or poor people, knowing that the poor can't defend themselves?
Oh, there's a loaded question. I think if you're a public authority and you've got a reasonable belief that someone's broken the law, or you take action against everyone as much as you can. I mean, and I think that's actually the problem here, is that the examples that you are identifying there are when people have broken the law, or there's a suspicion that they've broken the law. The problem with all of these devices is that they make that clearer, more out in the open. But ultimately, they're still breaches of the law. So there's a real question as to how, a philosophical question is how we deal with that. Are there grey areas in the law that we...
But my point in look at the rich-poor side of it is, the process of prosecution in itself can destroy a family. It can destroy a livelihood. You will lose your job, the stress on the family. We see this over and over again. Yep. Dealing with immigration is just an example as well. The cost of dealing with justice is prohibitive. So people will either give up and surrender for something which they didn't, simply to make it go away. Yep. And as a public authority, the temptation to hit your targets in terms of reclaiming VAT fraud or child benefit fraud or something, it's going to be so much easier to go after poor people than rich people, do you think?
Well, you're obviously trying to get me to go more. I mean, if you're a public authority, in my experience, and I'm a liberal. I know I'm in the Conservative group, but I'm a liberal. I'm sceptical of giving governments power because I do believe...
Is that an indication of where you're going after this?
I'm a classical liberal, so there's no... Sadly, the liberals in the Parliament are for me. But, now I've lost my train. The problem, in my opinion, is that you give public authorities or governments power. In my feeling, they tend to often abuse that and often go for the easy targets. Now, maybe I'm sort of getting close to answering your question. Yes, I think there's a temptation to go after those who can't defend themselves. And I think that's clear. And that's one of the reasons why I'm very... I said at the start, I prefer to give my data to companies than to governments, because they have a monopoly of the rule of force over you.
Okay. No, maybe Bobby want to follow up on this as well. I was dealing with a case recently to do with a murdered civil rights activist in Honduras. And during the discovery process in Honduras, they had something like 2,500 pages of WhatsApp messages. And in Honduras and generally in Latin America, there is no element of privacy with that. So once the discovery is made by the judicial authority, it becomes almost a matter of public record. Now, if I'm communicating with somebody in Honduras on something unrelated to the murder, obviously, then my data is completely exposed in the public frame. So how do we deal outside of Europe? How do we deal with countries like Honduras or Latin America in general with this?
I share the profound support or hope that good engineering and good computer scientists in the companies are already moving. And you see this generationally. I hate when people break down privacy on age, but there is an increased adoption of the kind of self-exploding email apps, of the end-to-end encryption, of privacy protecting elements of technology that I think we are all going to look at. I have to share that I did work at Amazon, and so I'm familiar with the Echo engineering, and that device overwrites the feed every 5 seconds intentionally to prevent long streams of conversation being collected. It's that kind of thinking by companies that we need to see more of, because we don't want thousands of pages of... Think of all your email. Think of all your whatever your email server is. To get off topic, we've done some work on digital decedents' assets. What happens to all those digital assets when you die? There's a roiling debate in the United States, at least in the Trust in Estates Bar, about the rights in that data. But we are all throwing off so much more data every single day as you walk down the street here and the street cameras. So we need to have better data limitation and better data deletion by governments and by companies.
Bob, can you follow up on that?
I don't have much more to add. I mean, it's a real challenge when we're dealing in an international context. You know, even within Europe, a lot of this either works or falls down based on national law, and that's one of the reasons that having something that can serve as a framework or an example, which may be something that can be constructed with Article 11 or other sorts of instruments to promote a due process, balance, data protection, all those kinds of principles in these kinds of very sensitive matters that affect people in a real way. That this is a reason to have a thoughtful discussion about some of these issues and try to build some of that into the legislation that we have available for us. But it's a very challenging issue, and I agree with Nuala that technology has a great role to play in terms of the best legal system in the world ultimately has moments, and technology is more reliable, I think. And so relying on technology is to the greatest extent possible while preserving public security as much as we can is a worthwhile goal, I think.
Nicholas, just follow on from that, is the best legal system in the world. I think none of us would hold our national institutions up as the best legal system in the world. Is this part of the problem? Is that we need to redress the inherent failures within the legal system in terms of due process, in terms of access to justice, and if we have more confidence in those elements, perhaps we wouldn't be quite so sensitive about this element of discovery of our private data as well.
Yeah, I think so. I think if you've only got a hammer, everything looks like a nail, right? So, and if you are legislator based in Brussels,
you win our code competition.
The thing you do is that you end up with another piece of legislation, and that not necessarily is the best possible answer to every problem that might be out there. And in many ways, technological answers might be more promising, but technological answers need working markets, and working markets need the atmosphere and the possibility to be developed. Yeah.
Do you think we should invest more in our judiciary to train them to a higher level to give the public greater confidence in the system, and that would go some way to solving this problem?
That could be one part of the issue. I think we would need to invest much more into, teaching people about what technology makes possible and the huge, vast amount of possibilities we have in this. That would be probably the most, if I had €1,000, that would be the target I would throw them to.
No, do you see it that way, that we could go a long way towards improving our judicial system to give public protection?
Sure. In my experience, and we've filed defender of the court briefs at the European Court of Justice, at the U.S. Supreme Court, at the appellate level in a number of countries, the courts are actually surprisingly getting it right. So the high courts are, because they've got more time to reflect, and we've been on the winning side of the last 5 or 6 technology cases. Net neutrality is still pending, by the way, just so you know, the latest swing in that pendulum. I think that's a good idea. I think much of the research shows that trust in institutions globally is on decline. And it's in the fourth estate, in journalism, in news and information, in governments generally, even in corporations. People are increasingly skeptical, and as they feel disenfranchised, they are more likely to act out and act in unpredictable ways, as we have all experienced. So I think there are some deep-rooted economic issues at play, and inequality. And I think the challenge for those of us working on tech and tech policy is to think about how there are unintended consequences. A lot of our research goes to inherent bias or implicit bias in algorithmic decision-making and in AI. That's something I think we should all be concerned about. And there's great promise in all of these technologies, and there's also some peril.
Okay. Any other questions before we finish up? Just to finish, let's go to the horror scenario, just because I find it interesting. Most of you will be familiar with China's social credit policy at the moment. My wife almost every evening now brings me another horror story. You were talking about this, and I didn't think it was real, but it's real. And the sense is that China is able to monitor certain urban populations to such a high degree that you won't have access to public transport if you didn't pay your parking fine, for example, or you're behind in your tax payments. 3 million people were denied access to internal flights in China because they failed their social credit status. So if you're at a certain threshold, I'm sure party officials are very high on the threshold, but if you didn't pay your parking ticket, you're denied public benefits as well. Now, I was in Ljubljana a few weeks ago, and we saw one of the Chinese companies, who I will not name and shame here, showing on the street of Beijing how quickly they could identify people on the street, how quickly they could match the data to their emails, all their tax data, everything else. They could bundle it, provided they had access from the government system as well. Your height, they could find you on the street according to your height as well. Now, I can think of 4 European governments off the top of my head who would love this technology. Who of you, with this in mind, has full confidence in our judiciary and legal systems to allow the access to your personal data? Bob? I'm going to come through each of you and finish with Nilda.
Easy question, right?
Yeah.
I mean, it's an enormous challenge. It's a stress test for, well, let's assume that you have independent institutions already and well-functioning checks and balances within your own legal system. And then even when you have that, I think it's a stress test for that. There's always a good reason identified for using this data. It's there, it's digitized, it's easily searched. And once you start opening that Pandora's box and start using it, it just becomes more easy and more convenient to do it. And having the ability, that long view of realizing the long-term effects of it, as you say, the sort of the construction of a society like China, where it's commonplace and accepted, or at least tolerated, in the sense of people have no feeling that they have another experience that they can expect. And that's a place that you don't want to go as a society.
Okay, it's quick answers from everybody. We're going to finish up in just a moment. So, same theme, Nicola. How do you see this play out?
Well, I mean, the main point is there is a slippery slope, and we need to be very careful in Europe because, you know, privacy is not that popular as it was several years ago. So we are down that slope a little bit already. I would still trust European courts, in particular the European Court of Justice, which has done great work in the last years on protecting fundamental principles of privacy. But I would mainly trust into society and into technology developments within the society.
Dan?
Well, I think you're describing an offline problem there. The problem there is the totalitarian autocratic government in China that is using the technology.
That's a growth market right now.
Well, yes or no. Do we have faith that our societies and our governments and our institutions are going to withhold whatever is coming? I think actually the problems we're seeing at the moment might be exasperated by the digital revolution, but they're actually set, that the base of them come from the financial crisis 10 years ago. And it's now feeding through in our system, and it's rocking our democracies, yes, but I'm sort of a little bit with Nuala that I think we'll see it through. And in the US, I think that's the case. I think the UK is a bit rocking as well, but I think we'll see it through in the end. So I do have hope in it. The problem with these sort of technologies is if you've got a totalitarian government and they have the ability to use these technologies, they also have the ability to change the law to allow them to use it.
Bogdan?
Earlier, actually, I mentioned necessity, and necessity is about the small harm for the greater good. And actually, we need something significant to trump our privacy. So
did you use that word deliberately?
Yeah, I think sounds nice. Yeah, and actually, I would like to just, as a closing remark, just to give an example. Yeah, evidence is not only about proving the guilt, but also the lack of guilt. So that could actually protect other of our rights, for example, right to fair trial, or even right to freedom.
Nuala, you have the final word.
I agree with Dan's comment that technology is a tool. It is not the cause of this inequality. It is not the cause of the loss of trust. But it is definitely a tool, and we who are tool makers need to make good decisions about what we are building and how we are building it. We as individuals have to decide how we are acting. Are we acting in furtherance of democratic institutions, or in our individual daily lives, are we not furthering free expression and good government and truth? And that goes to all people, public and private citizens. I saw a great speech recently by the chair of a politics department at a university who said Socrates had various definitions of the elements of a fundamentally thriving democracy, and institutional actors must act in service of the democracy as well as individuals. And so I think we all need to take that home and think about, are we for or against the values of democracy?
Perfectly ended. Thank you, and right on time. Also, let's thank our panelists, Bogdan Moachkov, Daniel Dalton, Robert Stanky, Nicholas Forgo, and Nuala O'Connor. Thank you so much for your contributions tonight.